Hello, welcome to U.S. Immigration Updates. The Department of Labor has created chaos for employers by denying applications needed to sponsor employment-based immigrants. The DOL has denied hundreds of applications for the Permanent Labor Certification (PERM) program based on how job titles are listed on a government form. The denials are unrelated to U.S. worker protections, according to attorneys. With thousands of PERM applications pending, employers say green card applications could be set back years, and some employees could be forced to leave the country. If you are interested in any of these topics, stay tuned to the end of this video for your immigration updates. If you enjoy this video, kindly hit the bell symbol, subscribe button, and like this video button to receive new updates right on your smartphone or other smart devices YouTube homepage. Now let's continue to watch the video and find out what's new in U.S. immigration. Before we go further, let's look at how PERM works. Obtaining labor certification from the Department of Labor is a crucial step in the process most employment-based immigrants undergo to get permanent residence or a green card. To meet the statutory requirement, DOL has required employers to test the labor market by placing advertisements before filling out Form 9089. The 15-page application for permanent employment certification includes sections that identify the employer, details on the prevailing wage and, in Section H, job opportunity information. The questions in Section H include: is experience in the job offered required for the job? And is experience in an alternate occupation acceptable? DOL has never issued guidance on completing the form, and companies have filled out the form in many ways, and government officials approved applications without ever indicating that they had a problem with how companies were completing the forms. So, what is the problem? A wave of denied PERM applications has hit law firms and employers in recent weeks, indicating that DOL has, without public notice, changed the way it adjudicates PERM applications. Attorneys say the denials became more noticeable in the fall of 2022 and increased more recently. A National Foundation for American Policy analysis of DOL disclosure data finds in the first quarter of FY 2023, October to December 2022, DOL denied more than twice the percentage of PERM applications as in the first quarter of FY 2022, October to December 2021, 6.8% versus 3.2%. DOL denied 1,670 PERM applications in the first quarter of FY 2023 compared to 866 in the first quarter of FY 2022. The data refute the idea that DOL has always adjudicated PERM applications the same way and that nothing has changed. The 6.8% denial rate for PERM applications in the first quarter of FY 2023 is higher than the denial rate of 4% in FY 2021 and 4.6% in FY 2022. In the last quarter of the Trump administration, the first quarter of FY 2021, the denial rate for PERM applications was 7.2%, but it dropped to 1.9% in the third quarter of FY 2021 during the Biden administration. More importantly, the denial rate for PERM applications has increased for 4 consecutive quarters, going from 3.2% in the first quarter of FY 2022 to 4.3%, second quarter FY 2022, 5%, third quarter FY 2022, 6.5%, fourth quarter FY 2022, and 6.8%, first quarter FY 2023. The denials are connected to Question H.10b of Form 9089, which asks employers to identify the job title of the acceptable alternate occupation required for the experience needed to qualify for the PERM role. According to Minor, the denials came without warnings, and it is unclear why DOL believes that the way employers are answering Question H.10b means the form is materially incomplete. Some employers list job titles or occupations such as a systems analyst or a software developer. Some answer more broadly, such as software engineering or similar occupation involving coding in C++, and some are even broader, pointing to the job requirements without referencing any specific job title or occupation. For the nearly 20 years that the PERM program has existed, all these approaches have been fine, and there were never denials from DOL relating to how this question on the form was being answered. So, what is the big impact of this on your petition? If a PERM application is denied, it could delay the green card process for a year and a half or more. It might prevent someone in L1 status from being approved before their maximum period of stay is exhausted. The practical impact of these denials is significant, and they will likely further slow DOL processing times if they continue. PERM processing times are currently more than 8 months, and tens of thousands of PERM applications await DOL adjudication. Unless corrected, he foresees a massive waste of employer and government resources as employers file a request for reconsideration and ultimately an appeal to the Board of Alien Labor Certification Appeals. Now, let's look at what could be the solution for it. In the eyes of employers and attorneys, DOL has created chaos, confusion, and a lack of predictability. However, there is hope for a solution. The American Immigration Lawyers Association's AILA DOL Liaison Committee has discussed the issue with DOL's Office of Foreign Labor Certification. DOL has agreed to review cases where the PERM denial was based on question H.10b, according to AILA's committee. OFLC recognizes the inconsistencies in their adjudications over the years and has agreed to review applications where the employer has filed a request for reconsideration, RFR, based on the question H.10b denial. Where the reason for denial is question H.10b only, OFLC will pull the case out of the usual order to review and certify the application where appropriate. OFLC has indicated that there are several hundreds of these cases. While OFLC will start reviewing these cases immediately, it may take several weeks to process them all. According to AILA, if you have received a denial of Form ETA 9089 based on question H.10b, please file an RFR indicating in your request that the case was denied on the basis of question H.10b. If you have already filed your RFR, no further action is needed. If your application is pending, no action is needed yet. Melmed also welcomed the DOL update but advises caution. There is reason to be optimistic, but DOL has a long way to go to make things right. All of this could have been avoided if they had just followed the law and provided notice to the public. Kevin Miner says the broader solution is straightforward. Number 1, DOL should immediately pause issuing denials on this basis while the agency addresses the problem. Number 2, DOL should issue guidance, including frequently asked questions, for how the agency wants employers to answer the question that has generated so many recent denials. Number 3, DOL should reopen denied cases that were denied on this basis. Number 4, DOL should process the pipeline cases, including the reopened cases that were previously denied, consistent with prior adjudication practices, with any new interpretations from DOL coming only after issuing new guidance. I hope you found this video useful. We will post new videos when there are more updates. The U.S. Immigration Update channel provides the latest U.S. immigration news, USCIS policies, NVC processing, embassy, and visa process updates to help you on your U.S. immigration journey. Understanding the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more is essential. We will continue to provide comprehensive information regarding U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, EB5, and family immigrant visas. Thank you for visiting us today and see you in the next video. If you haven't subscribed to our channel, please subscribe to our channel for more U.S. immigration update videos.